Good evening, participants. Welcome to today's webinar on Formation of Apartment Association, Law and Practice in Karnataka. Thank you all for joining us today. Before we dive into this important topic, I'm truly honored to introduce our speaker for today, Sohail Ahmed sir. He's an advocate by profession. Let me share a bit about Sir's vast experience and contributions. He is a partner at Trialbase, a distinguished law firm in Bangalore, as well as a partner at Smriti Legal LLP, specializing in RERA litigation and advisory services. Currently, he serves as the principal consultant for RERA Consultants LLP, advising on RERA related matters across Karnataka, Telangana, Andhra Pradesh, Kerala, and Tamil Nadu. With an impressive 23 years of experience in property law, he is well regarded for his deep knowledge in property, corporate, and civil laws. Suhail sir has also held key positions such as former chairman of legal committee and member of the core committee at National Real Estate Development Council in Karnataka, as well as roles in committee at the Jawaharlal Nehru Center for Advanced Scientific Research. He is a governing council member of Naredco Karnataka and currently serves as president of L&T Raintree Boulevard Apartment Owners Association, a community of 2,240 apartments. A passionate advocate of the Real Estate Regulation and Development Act 2016, Suhail sir has worked tirelessly to spread awareness of RERA across southern India and has conducted workshops for organizations such as Telangana Real Estate Regulatory Authority, Naredco Karnataka, Kradai Mysore, and many more. He has been a Rotarian for the past 14 years and is a member of Rotary Raj Mahal Vilas in Bangalore. With over 2 decades in real estate law and a dedicated focus on RERA since 2016, he advises promoters, consumers, and apartment owners association across the southern states of South India. Today, Sir will discuss on the legal framework for forming an apartment owners association, the step-by-step process of setting up an association, challenges commonly faced during the formation, recent judgments and their implications. Without further delay, please join me in welcoming Suhail sir to take us through this insightful session. Sir, over to you.
Thank you, Pradeep, for the introduction, and Vishwas for giving me this opportunity to talk. I just in Karnataka, the law and practice. I'll be talking about that. Of course, the question of formation of a association is continuously being debated in the state of Karnataka. Because the laws which govern the law which governs the formation of association can say for the purpose of maintenance and management of the common areas in an apartment complex is governed by Karnataka Apartment Ownership Act. However, there are different views as regards the formation. I'll be discussing the various statutes which are currently in force in Karnataka, and associations have been formed under these statutes, and these associations are taking care of the maintenance and management of the association. Of course, there has been talk of a new enactment being made for this, or the existing enactments being amended to suit the present requirements. However, we are yet to see that happening, but there are all indications that that should happen very soon. And recently, in fact, the Tamil Nadu government has enacted a new Tamil Nadu Apartment Owners Association Act, Tamil Nadu Apartment Ownership Act. Maybe we can expect something on the similar lines in Karnataka also. I'm conducting this session for RERA Consultants LLP, and I thank RERA Consultants LLP for giving me this opportunity. I'll be talking about the relevant statutes, the objects, requirements, and applicability of these statutes, relevant provisions of these statutes and the regulatory provisions, and then coming to formation of Apartment Owners Association. I'll also talk about the disputes and dispute resolutions in the associations. If anyone has questions, either you can ask to be unmuted and you can ask me questions in between, or you can send the questions in the chat. I'll be more than glad to answer these questions. So the statutes that I will discuss: the Karnataka Apartment Ownership Act 1972, which is commonly known as KOA, or the 1972. Coming to the objects and requirements of KOA 1972, the concept of ownership of an apartment, the culture of the apartment buildings being built and separate ownership being given to each apartment owner of the undivided share in the land, undivided interest in the land, I would say, not the share, uh, was felt necessary, and each apartment individually was required to be made heritable and transferable. At that point of time in 1972, as I know, as far as my knowledge goes, it also became necessary for bankers to extend loans to purchasers of apartments. It was felt necessary that because the concept of an undivided interest being transferred was not in existence at that point of time. Of course, the Transfer of Property Act enabled transfer of portion of a interest in a property, but however, in the nature that is in an apartment where the undivided interest is required to be transferred to an apartment owner, that was not there. So, in order to make each apartment heritable and transferable, the KOA was enacted, and each apartment, together with its undivided interest in the common areas and the facilities to such apartment, is constituted for the all by heritable and transferable immovable property. So that is what the intent, the object of this act was. So how does an apartment complex get submitted to the provisions of this act is the sole owner, all the owners of the property submit the apartment complex or the apartment building to the provisions of the act by executing a deed of declaration, which is otherwise known as the Form A, as provided under the act. So I'll be discussing how the sole owner and all owners as we go further. And the intent was to give each owner exclusive ownership and possession of the apartment. And the each apartment owner, in addition to execution of a Form A, which is executed by the sole owner or all owners, is required to execute a Form B, a declaration in Form B, stating that he or she submits the apartment to the provisions of the Act and a deed of apartments. That is the same deed. So then there is also the restriction that the common areas shall not be divided or partitioned, and it also provides for carrying out the work of maintenance, repair and replacement of common areas and facilities that will be provided as per the bylaws, which is required to be annexed with the deed of declaration. So this act applies only to such properties which submit the apartment complex to the provisions of the act, and it shall be and which is also important to note that these properties are mainly used or proposed to be used for residential purposes. If there is a mixed use, then it cannot be like there are a portion of the apartment complex, there is shopping complex, and then the remaining portion is an apartment. Then the provisions of KOA cannot be applied in the sense that the deed of declaration in respect of such a complex cannot be executed, and this cannot be submitted to the provisions of KOA. When there is a COFA essentially is regulatory in nature. Prior to, if you see the provisions of COFA, they are almost similar to that of the Real Estate Regulation and Development Act, in the sense that in order to regulate the construction, as we saw the name of the act, regulation of the promotion of construction, sale, management, and transfer, which is nothing but what RERA also intends to do under the new enactment. So, it being regulatory in nature, it intended that if individuals or group of individuals who construct out of their own funds multi-story buildings and sell them to individuals on ownership basis or collecting. So it was intended to apply to such a group and it is to protect the interest of the intending purchaser who advance funds. So, in order to regulate the construction, sale, management, and transfer of flats or apartments by such individuals or group who construct these multi-story buildings. Flat is defined under COFA, and if you see the meaning of the flat, it includes not just residential premises. It also includes commercial premises. So to speak, COFA not does not exclusively apply to residential buildings, but also mixed development buildings, which the intention of which is to regulate the construction and sale of such buildings. So has kind of changed the way it functions. The objects of RERA is primarily to establish a real estate regulatory authority for regulation and promotion of real estate sector. COFA, though, was in the nature of a regulatory statute, it did not have a regulator. So, in the sense that there was no authority which was appointed under the Act to enforce the provisions of COFA. Now, which is what RERA now does, with the regulatory authority being there under the Act, and the regulatory authority is entitled to not only carry out the functions of being a regulator, but it also carries out the functions of being a quasi-judicial authority in the day, and is entitled to entitled to adjudicate of the complaints that are filed by the allottees in the project as against a promoter, and by the allottees as against a real estate agent. It also empowers a promoter to file complaints against allottees if the allottees also do not adhere to the provisions of the Act or the agreements that they enter into with the promoters. RERA also intends to ensure the sale in the real estate project in an efficient and transparent manner. So to speak, that now RERA mandates that the allottee, when he or she purchases an apartment in a project, all the documents which are required to be given in respect of that project are required to be handed out. All the details relating to the project are to be given. In fact, even RERA mandates that stage-wise time schedule is to be given to the allottees in the project. Then next is, of course, to protect the interest of the consumers. We can say that RERA basically aims to protect the interest of the consumers in the project. So all the disputes that we see now predominantly are filed by the allottees against the promoters of the project. The disputes that get settled under RERA not only relate to delays in the project, but also other matters relating to associations also. It can also be relating to handing over of corpus, handing over of common areas. So even such disputes are taken before RERA, and RERA does adjudicate such complaints. The Act also aims to establish an adjudicating mechanism for speedy dispute redressal. Of course, the time is stipulated for the adjudication of the disputes. However, in view of the large pendency, of course, that those timelines are more often than not adhered to. But nevertheless, the mechanism to file the complaint and seek adjudication is pretty simple. An appellate tribunal is also established under the Act, to where the orders passed by the regulatory authority or the adjudicating officer under the adjudicating officer can be challenged. And this Act governs all real estate. Okay. So next is the objects and requirements of the Karnataka Cooperative Societies Acts 1959. As we know, in Karnataka, mostly everybody either refers to the 1972 Act, 1960 Act, and 1959. The 1959 Act is the Karnataka Cooperative Societies Act. This Act aims at consolidating and amending the laws relating to the cooperative societies in the state. And this governs cooperative societies which have in their objects promotion of economic interest or general welfare of its members. So it is under this general welfare of its members that an association which can take care of the maintenance of an association can also be formed. As we go further, we'll discuss that. A cooperative society is to be governed by its bylaws. Of course, minimum of 10 applicants is required to seek registration, it says. But however, as I know, minimum of 20 applicants are required. So Karnataka, next is the Karnataka Societies Registration Act, otherwise known as the 1960 Act. So this act provides for registration of literary, scientific, charitable, and other societies. So Section 3 provides for these objects, which means that any association that is formed under Karnataka Societies Registration Act has to be within has to have these objects. If these objects are not there, then if such associations carry out the functions of maintaining an apartment complex, then such associations are cannot do so. And in the event of the same being challenged, the courts will set aside the registration of these associations which are formed under KSRA. And we have seen recently that Karnataka High Court has been ordering for the registration of such associations which are carrying out the activity of the maintenance are being struck down and the registrations being cancelled. So, as you can see, it applies to societies which are established for charity, education, science, promotion of sports, diffusion of knowledge relating to commerce, diffusion of political education, foundation or maintenance of libraries. I'd like to add that now we know that there are many projects which are either stalled or stressed or where the promoter has abandoned the projects. In such case, of course, for the welfare of the allottees, in order for them to come together and agitate for their rights, to seek for completion of the project, an association under KSRA can be formed, which can be for the general welfare of the allottees in the project. However, it can only be limited for that purpose, and as such, it is not mandatory also under RERA for an association to be formed. However, it becomes easier for everybody to come together, contribute, and then take up the litigation or anything else that needs to be done as against a promoter to ensure that the project is completed. An association under KSRA can be formed. However, for the purpose of carrying out the maintenance activities, an association under KSRA cannot be formed. And also there are certain notifications and circulars also issued barring the same. So these are the other objects, of course. For the purpose of formation of an association under KSRA, minimum of 7 persons are required. So thereafter, all the other apartment owners or allottees in the project can be added as members to the association which is formed under KSRA. Now coming to the important provisions of these enactments as provided under the provisions of KOA. Once it is executed and registered, only then it can be said that the apartment complex comes under the statute and can be governed by the statute. An apartment as defined under the act it is a property intended for sole use for residential purposes. So the differentiation between COFA and KOA, under COFA, a flat as defined includes a residential premises as well as a commercial premises. However, under KOA, an apartment is defined, and it is only when it is only intended for solely for residential purposes. An apartment owner, of course, doesn't need to be elaborated. It is a person who owns an apartment and an undivided interest in the common areas and facilities in the percentage specified and established in the declaration. When under KOA, the undivided interest, which is now, of course, by virtue of practice, it is called as UDS, undivided share. However, the Act requires that it is an undivided interest and it has to be defined in terms of a percentage that, of course, some of the promoters continue to state by way of a percentage, but many promoters now have converted that into a square feet, but it is necessary that, or the act requires that a percentage, it has to be done as by way of a percentage. In addition to percentage, the exact square feet, or in terms of square feet also it can be defined. So it is essential to keep in mind that when the undivided interest is being conveyed, so a percentage should be given, as also the conversion of the same into the square feet. The next is the most important, I would say, that the association of apartment owners. How the act defines is that all apartment owners acting as a group in accordance with the bylaws and declaration. So it's a very simple definition. The association of apartment owners, which comes into being by virtue of the bylaws that get annexed with the DOD, it's a group of apartment owners who come together and act as a group in accordance with the bylaws and declaration. So it's a very basic requirement or the basic definition of the apartment owners association. And this association, let me tell you, can carry out the functions of maintenance and management of the common areas in an apartment complex. So the role of this association is limited to carrying out the maintenance and management of the common areas that get submitted to the provisions of the act under the deed of declaration. We'll see what are common areas as defined under KOA. So the common areas and facilities under the KOA as defined under KOA, it includes the land on which the building is located, which of course is also the definition under section 2N of RERA, which includes the entire land on which the building is located. So everything else which forms as part of the common areas are included, like foundations, basements, parking areas, all other portions of the project which are intended for common use, central services like power, light, gas, hot and cold water, air conditioning, elevators, pumps, all of these form part of the common areas, and it is essential that these are defined in the deed of declaration or listed out in the deed of declaration along with the details of the apartments as well as the undivided share. The only difference between the definition of common areas under KOA and under RERA is that under the definition of the KOA, all the parking areas are defined in common areas. However, in the definition of common areas under section 2N of RERA, only the open parking areas are brought under the definition of the common areas. So which means that the covered car parking areas are left out from the definition. That is why now under RERA, if you see, the covered car parking areas are also sold as a single indivisible unit along with the apartment. And in fact, promoters also charge additionally now. Earlier, because of this definition of inclusion of parking areas, in fact, the apex court also had held earlier that parking areas cannot be sold. So now, by way of the definition of the common areas having been changed to include only open parking areas, now the covered car parking areas can be sold and transferred under RERA. So common expenses is the next definition. All sums which are lawfully assessed against apartment owners by the association and agreed as common expenses by the bylaws, declared as common expenses by the act or declaration or bylaws. So one should understand that, of course, once in the deed of declaration, it is made mandatory that all the apartment owners will become the members in the association. So essentially, all apartment owners by default are deemed to be the members of the association. Number two, they are also governed by the bylaws. So in effect, it is I would say, it is a it is a contractual relationship between the apartment owners as well as the association, under which the members agree to adhere to all the things that the association does. When maintenance charges are fixed, any other charges are fixed, any other restrictions are imposed, any other liberties are given. So all of these are required to be adhered to by the apartment owners. So the common expenses which are otherwise most what we know as CAM, that is common area maintenance charges, are required to be paid by all the owners. And this is what the common expenses mean. Common profits is the next definition, which is the balance of all income, rents, profits, and revenues from common expenses remaining after deduction of common expense. Limited common areas, we saw the definition of common areas. Now, under the deed of declaration, limited common areas also can be declared in the deed of declaration. So, these are areas which are, by virtue of the declaration, are reserved for use of certain apartment or apartments to the exclusion of other apartments. These could be the private terraces or private gardens or any such area which are meant for the exclusive use of the apartment. But one has to keep it in mind that these private terraces or private gardens should form part of the sanction. Merely because a promoter declares these as limited common areas and facilities, it cannot be said so. However, these should form part of the sanctions that are obtained for the project. So in the sanction, if it is shown as a private terrace, only then it can be declared under the deed of declaration as that being a limited common areas. Majority under the provisions of KOA for all purposes is said to be is 51% or more of the votes in accordance with percentage assigned. I have seen deeds of declaration where instead of stipulating majority, the for the purpose of amending of the bylaws or for the purpose of amending deeds of declaration, 100% is stipulated, which is impossible to achieve. So while drafting bylaws or making bylaws, it is essential to retain this, the definition that is given in section 3N, a simple majority of 51% or more should be enough to seek amendment to the deeds of declaration or the bylaws. Section 4 defines the status of the apartments. So each apartment, together with its undivided interest in the common areas and facilities, shall for all purpose constitute heritable and transferable. So by virtue of this, an apartment owner can transfer his apartment and the percentage of undivided share in the common areas by way of sale. So the status of apartments is given under section 4, which makes an apartment heritable and transferable. This is the basic object with which the act was enacted also. So the common areas and facilities, the common areas and facilities, the percentage of undivided interest, it will have a permanent character and it cannot be altered by anyone without the consent of all the apartment owners, and it shall never be separated from the apartment to which it appertains. So, which means that once the apartment with its carpet area and the undivided share or the super built up area along with the undivided interest is transferred, it at no point of time it can be altered or separated from the apartment by any means, which also means that just to in terms of just to say this, now the apartment and the covered parking is conveyed under a sale deed. So it cannot happen. Of course, it is not in relation to this. I'm just adding to this. In relation, when if a particular allottee intends to sell a car parking separately without selling the apartment, that cannot be done, because even under RERA, under the agreement of sale, which is notified under the rules, it is said that these two are to be treated as a single indivisible unit. This cannot be done. It cannot be done. So now coming to the contents of the deed of declaration, which is the form A. So what is required to be put into this deed of declaration is the description of the entire land, the extent of land, the details of the land with the survey number or the khata number, municipal number, all those details, the description of the building, a number of stories, basements, and the apartments, apartment number of each apartment, the entire description has to be given, and approximate area. Now it is because the RERA stipulates that only carpet area is to be sold. The description of the carpet area, the limited common area, as well as the common area should be set out in the deed of declaration. For your information, the carpet area is defined under RERA, which is the net usable area, including the internal walls and excluding the external walls and the verandas and the other the shafts. So this is the carpet area. Limited common areas can be, now the balconies are limited common areas because that is not included within the definition of the carpet area. The common areas are the rest of the common areas which are defined in section 2N, which also I spoke earlier about. So these are the three things. All these three put together constitute the super built up area, which is also mentioned in all the sale agreements now and in the sale deeds also. In fact, even the stamp duty is calculated on the basis of the super built up area and not on the carpet area. So in the deed of declaration which gets executed now, it is essential that the number of each apartment and the areas are also set out. Description of common areas in terms of the clubhouse, the basements, all other common areas that are there in the project should be given in detail. Description of limited common areas, if any project has private garden, private terrace, or private balconies, which certain apartments have larger balconies or decks which are which connect each one tower to the other. So these can be set out as limited common areas. However, as I said earlier, they should form part of the sanctions itself. The value of property, each apartment, and percentage of undivided share in the common area and facilities and voting. This, of course, is what is stipulated under the Act. Value of the property, most often than not, is not given. But however, the percentage of undivided interest in the common areas is required to be set out. Purpose of use of each apartment, of course, it cannot be anything other than residential. Name of person to receive service of process. Most often than not, this is the secretary of the association. Provision as to percentage of votes by the apartment owners, which shall be determinative whether to rebuild, repair, restore, or sell the property in the event of damage or destruction of all part of the property. This is in case of a redevelopment. Currently, now we are not seeing too much a lot of redevelopment happening in Bangalore, but in other states, of course, Mumbai is seeing a lot of redevelopment, and I think there is also a separate enactment being enacted, has been enacted for redevelopment. The method by which the DOD may be amended, consistent with the provisions of the Act, like I said earlier, it should be by a simple majority, and it should not become oppressive by saying that 75% of all the owners or 100% of all the owners, because even getting a simple majority of 51% is very difficult today, because most of the apartments are purchased and rented out, and the apartment owners most often than not do not reside there. So getting a majority or getting a consent or the approval of the general body consisting of majority of the apartment owners becomes very difficult. So this care should be taken that the method in which the DOD can be amended should be set out by saying that a simple majority. Requirement under the Act of a true copy of the declaration and the bylaws, and subsequently if there are any amendments to the bylaws, to the declaration or the bylaws, they should be filed in the office of the competent authority. Now, who is the competent authority under the Karnataka Apartment Ownership Act? Section 3 defines the competent authority. When it is in relation to any building constructed by a housing board, it is the secretary of the housing board. In any other case, it is the registrar of cooperative societies as defined under the Karnataka Cooperative Societies Act 1959. So what is it that is required to be done under section 11 subsection 2? That is that a true copy of the declaration shall be filed in the office. It is, of course, though the registrar of cooperative society does not exercise any jurisdiction or has not been given any power under these acts to carry out any functions or to enforce any of the provisions of the act. However, what is stipulated is merely submitting a true copy to the registrar of the cooperative societies, which should be done once the deed of declaration is registered. So the deed of declaration, how does one, the act requires that the declarations, of course, deed of apartments is now the sale deed, and copies of floor plans should be registered under the Registration Act before the jurisdictional sub-registrar. So what it means is that deed of declaration, as provided under the Act, is required to be registered before the jurisdictional sub-registrar. So section 16 speaks of the bylaws and their contents. So when a deed of declaration is executed, along with the deed of declaration, as an annexure, these bylaws are annexed. And what these should contain is that to state that the administration of every property, that is every apartment complex, to be governed by these bylaws, a true copy of which is to be annexed to the declaration. So this becomes part of the registered document that gets registered with the sub-registrar. And it should provide for election of the board of managers, method of calling meetings, election of president, secretary, treasurer, and other office bearers, maintenance, repair, and replacement of common areas, method of adopting and amending the administrative rules and regulations, and restrictions on use and maintenance of the apartments and common areas, and the percentage of votes required to amend the bylaws. So this is what is to be set apart. Of course, the bylaws can also be, the model bylaws are already given under the KOA Act. It can also be, they can also be drafted in such a way that it meets the requirement of a particular apartment complex. As we know, some are small apartment complexes, some are large apartment complexes. And now we have apartment complexes which are so large that we have multiple towers, multiple phases, and then there is also common areas which are common to all. So it can also be done in such a way that there are associations formed for each tower or phase, and then an apex association which takes care of the maintenance of the core common areas, and then these tower associations separately take care of the maintenance of these individual towers or phases. That can also be done. That can be done by stating so in the bylaws in terms of how these different towers or phases can be managed. It will also require that accordingly the deed of declaration would also have to be executed in such a manner to speak of the management and maintenance being done in this manner, where it's a kind of a federal structure where different towers or phases are administered their own towers or phases separately, and then for the purpose of maintenance of the core common areas like the clubhouse and other areas which are large in nature can be done by an apex association. I've seen that happening, and I'm sure most of you would also have come across that where there are large projects where the number of apartments are huge. This can be done. It is also the choice, of course, sometimes the choice is not given because the deed of declaration and bylaws get executed by the promoter itself, drafted and executed. And sometimes there is no foresight in this, and that is when the requirement to amend the deed of declaration by a simple majority comes into force. So these are the bylaws. This is how the bylaws have to be can be drafted, and these are the bylaws that get submitted along with the deed of declaration. Next is the charge on property for common expenses. Next is the charge on property for common expenses. The sums that are assessed, which are basically the common area maintenance charges, which remain unpaid, will constitute a charge on such apartment prior to all other charges except government. So, which means that this entitles an association to seek for recovery of the camp charges from an apartment owner if it remains unpaid. Of course, how this can be done, I will discuss it a little ahead. But the common area expenses are deemed to be a charge on the apartment under Section 19 of KOA. So, Section 20 speaks about the joint and several liability of vendor. That when the sale of an apartment, the purchaser of such an apartment is deemed to be jointly and severally liable with the vendor, that is the person who sells, for all unpaid assessments for his share of the common expenses up to the time of the sale. So this becomes relevant when the common, let's say that when you take a period, some of the apartments get sold right at the beginning, some of the apartments get sold at the time of completion, some of the apartments remain unsold even after some time from the date of the occupancy certificate being obtained, and majority of the apartments being sold. So when this happens, if a purchaser purchases an apartment, let's say 1 year or 2 years after the majority of the apartments are sold and possession is handed over and the maintenance activity has commenced, for the period from the time the maintenance activity has commenced up to the period the sale takes place and the new purchaser takes possession, if there are any maintenance dues, such a purchaser would become liable to pay the maintenance dues. So this is what the Section 20 implies. So under the rules, of course, KOA rules, Rule 3 speaks about the DOD to be in Form A, and Rule 4 speaks about the Form B that is required to be executed by each apartment owner. And bylaws, it speaks about bylaws to be as per Section 16. And the draft bylaws annexed with rules requires each apartment owner to hold at least one share of the association. This is not the draft bylaws, though require this, but it is not practiced. I have not seen it happening at all. But this would be in the nature if you equate this with a cooperative society, then going by the Maharashtra model, where an agreement for sale is executed and a deed of transfer is of the entire land is executed in favor of the cooperative society. By virtue of owning the shares in the cooperative society, the apartment purchasers become co-owners of the entire land. So it would be in that nature, but however, this is not practiced so far in Karnataka. Maybe in future, once the government amends the act and mandates it, this can happen. In case of course, this in case of joint owner share certificate to be in joint names, and voting, regular meetings and annual meetings, special meetings, notice of meetings, etc. So all of these are to be prescribed or stated in the bylaws, and they should be done as per the bylaws. If you just excuse me for a moment. So under the KOA rules, as per the bylaws, the voting in case of an election or for any other purpose, it is to be on a percentage basis, and the percentage of vote to which the owner is entitled is the percentage assigned to the family unit or units in the declaration. So this most often, of course, this is not done, and if it is if it is done, it is good in terms of what is the percentage, the weightage of the percentage that is given to each unit can also be set out in the bylaws. Quorum, if except as provided in these bylaws, the presence of in person of a majority of owners shall constitute a quorum. But this, for the purpose of meetings, this can be amended a bit because it is impossible to get the majority of owners, let's say, to even attend an annual general body meeting. So the quorum can be the members present. It can be the members present at an adjourned meeting, which is that if in case an AGM is called, the bylaws can be written in such a way that the member, if there is no majority, the meeting can be adjourned by an hour, half an hour, or by a day, whatever suits the particular society. Then the members who are present at such an adjourned meeting can be said to constitute a quorum, because it is impossible to get a majority of owners to attend any meetings today. So vote to be cast in person. Some of the associations, as I know now, also allow voting online. So this of course is there in the bylaws, and knowing that these rules were framed in 1972, they would not have factored. Of course, the present requirements require that it can be in a hybrid mode where people can also vote in person and also online, provided that the online voting is secure and is not does not become questionable at the end of the day. So meetings under KOA rules, general meetings, AGM, SGM, AGM, as per the model bylaws, the AGM should be held on a designated date as set out in the bylaws each year, and generally this is around June or July. Also, in the AGM, since the financials are required to be submitted, if in the bylaws, if it can be, if the AGM can be set to maybe September, then it becomes easier for the management committee or the board of directors, the board members, to be able to present the financials to the community. And of course, in all the AGMs, most of the AGMs, the election to the office bearers is also conducted, depending on whether the members of the MC members or the EC members, however they are called. So they are to be elected. If it is by rotation, some of the associations have a particular number retiring one year, another batch going in second year, and the last going in the third year. Depending on whatever is stipulated in the bylaws, the elections to these office bearers also can be conducted along with the AGM. SGM, as per the bylaws, the model bylaws, can be called by the president as directed by a resolution of the board or upon a petition signed by majority of the owners. This in the bylaws, it can be set out in any manner, or in the manner which is most feasible for a particular association, because if a majority of owners in 1,000 apartment project, then it becomes impossible. So that is why it can be made a little simpler and easier. And of course, it goes without saying that whether a special meeting or an annual general body meeting, the time and place of the meeting should be given. And in a special meeting, no other business to be transacted other than what is stated in the notice. Transacted other than what is stated in the notice. Under COFA, in section 10, which deals with the flats which are either residential or commercial in nature, it is directed that the promoter of a project should take steps for formation of cooperative society, and this he should do as soon as minimum number of persons required to form a cooperative society or a company have taken flats. So this, in comparison to the Real Estate Regulation and Development Act, Section 11(4)(e) of the Real Estate Regulation and Development Act stipulates that within 3 months from the majority of the apartments having been booked, the promoter should facilitate in formation of an association of allottees. So this can be as per the local laws, is what RERA stipulates. So which means that the promoter of a project now, by virtue of Section 11(4)(e), is required to form an association immediately upon 51% of the apartments having been booked. So though this COFA requires that a cooperative society or a company is to be formed, but however, now with RERA, and since the provisions of RERA will prevail over the provisions of COFA, we can say that we'll have to follow what is written in the what is stipulated under RERA. And COFA, this requirement can be said to be relevant when it is a project which has residential as well as commercial developments where a cooperative society can be formed or a company can be formed. So under COFA, the general liabilities of a person who takes a flat are also stipulated. So which mandates that a person who takes a flat shall pay the municipal taxes, water and electricity charges in respect of the flat taken by him, and where a cooperative society or company is to be constituted, cooperate in formation. So this is what the general liabilities of a person who takes a flat. This is also there in RERA under Section 19, where it is mandated that the allottee should also participate in formation of an association and also should discharge his or her duties or obligations in respect of the apartment that is purchased. I'll not discuss the model bylaws under COFA transacted other than what is stated in the notice. Under COFA in Section 10, which deals with the flats which are either residential or commercial in nature, it is directed that the promoter of a project should take steps for formation of cooperative society, and this he should do as soon as a minimum number of persons required to form a cooperative society or a company have taken flats. So this, in comparison to the Real Estate Regulation and Development Act, Section 11(4)(e) of the Real Estate Regulation and Development Act stipulates that within 3 months from the majority of the apartments having been booked, the promoter should facilitate in formation of an association of allottees. So this can be as per the local laws, is what RERA stipulates. So which means that the promoter of a project now, by virtue of Section 11(4)(e), is required to form an association immediately upon 51% of the apartments having been booked. So though this COFA requires that a cooperative society or a company is to be formed, but however, now with RERA, and since the provisions of RERA will prevail over the provisions of COFA, we can say that we'll have to follow what is written in the what is stipulated under RERA. And COFA, this requirement can be said to be relevant when it is a project which has residential as well as commercial developments where a cooperative society can be formed or a company can be formed. So under COFA, the general liabilities of a person who takes a flat are also stipulated. So which mandates that a person who takes a flat shall pay the municipal taxes, water and electricity charges in respect of the flat taken by him, and where a cooperative society or company is to be constituted, cooperate information. So this is what the general liabilities of a person who takes a flat. This is also there in RERA under section 19, where it is mandated that the allottee should also participate in formation of an association and also should discharge his or her duties or obligations in respect of the apartment that is purchased. I'll not discuss the model bylaws under COFA. So let me come to the relevant provisions of RERA, which is what I just spoke of, section 11(4)(e), which stipulates that the promoter should enable formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same. So in the absence of local laws, that is, if there is no prescription as to when this should be formed, the association of allottees by whatever name shall be formed within a period of 3 months of majority of allottees having booked, which is just what I spoke a little while earlier. So this is what RERA mandates now in terms of the formation of an association, and this is the association which can also go on to maintain and manage the apartment complex. So the next is section 17, which deals with transfer of title. I am talking about the transfer of title, which of course does not deal with the formation of an association, because RERA now mandates that the undivided proportionate title, that is, a conveyance deed, should be executed in favor of the allottee, along with the undivided proportionate title in the common areas to the association of the allottees, and hand over physical possession of the apartment to the allottee and the common areas to the association of allottees. So though it is now mandated under RERA that the undivided proportionate title in the common areas is to be transferred to the association, and those common areas are to be handed over to the association of allottees. In the state of Karnataka, this is not possible to do because the government has not enabled the transfer of the common areas to the association of allottees. To my knowledge, I think only the state of West Bengal has issued a notification wherein the common areas, the entire common areas, can be transferred to the association of allottees by paying a nominal stamp duty. Now, the issue is that the land continues to stand in the name of the earlier owner, and when the apartment is sold, only the khata relevant to the or the municipal records relevant to the apartment get mutated and transferred to the apartment owner's name. However, the land continues to be in the name of the earlier landowner, which is certainly not desirable, because there are cases where I recently came across a case where the government issued a notification for acquisition of portion of the land. Now that notice then gets served to the landowner, and then the landowner then starts making a claim that I am entitled to the compensation that is given for acquisition, while that landowner has already sold and exited the project years ago. So it is also the risk that in case of a redevelopment or anything, there is a damage to the entire apartment. How do the apartment owners come together and develop the property? So of course, the requirement under section 17 of RERA is necessary to be complied with. However, in the state of Karnataka, it is not possible to be done now because the state government has not yet enabled it, and once this gets enabled, it is the most apt thing. If it is transferred, then the khata of the entire land would also come to the association. Then the association, with all the apartment owners as its members, will become the co-owners of the entire land. So that is the relevance of Section 17 of RERA. 17 of RERA. So Section 89 of RERA says that the Act shall have an overriding effect. So which means that notwithstanding anything inconsistent and therewith contained in any other law for the time being in force, this Act to have effect. So which means that the provisions of KOA and KOFA, which are inconsistent with RERA, seem to have an effect. In fact, while the apex court rendered the judgment in respect of the West Bengal HERA, which is West Bengal had enacted its own Regulation and Development Act called WB HERA, the apex court set aside that enactment. While doing so, many of the acts which are in the nature of KOFA were set aside. However, specifically, there was no mention of KOFA in that judgment. The in Maharashtra, the concept or the because the apartments, the culture of apartments is predominantly more in Maharashtra, particularly in Mumbai. As I know, the Apartment Ownership Act in Maharashtra has undergone several amendments, and the Cooperative Societies Act also defines a housing society under Section 216, which is a society, the object of which is to provide its members with open plots for housing, dwelling houses or flats, or if open plots, the dwelling houses or flats are already acquired, to provide its members common amenities and services. So by virtue of this, cooperative societies are formed. However, as I discussed earlier, in Karnataka Cooperative Societies Act, the only provision is general welfare of members. So it is under that provision, and it is essential that the government includes the definition of a housing society, if at all the management and maintenance and transfer of the common areas in the apartment or the maintenance and management is to be done by a cooperative society, it will become essential to either amend the Cooperative Societies Act or amend the Karnataka Apartment Ownership Act to bring in these aspects, and also appoint a competent authority who can administer, regulate these associations, which partially has been done by the Tamil Nadu government by enacting the new amended Tamil Nadu Apartment Ownership Act. So this inclusion of housing society is not in our Karnataka Societies, Karnataka Cooperative Societies Act 1959. Okay, CA not relevant. There is a circular which is dated 30/11/2018, issued by Registrar of Cooperative Societies, which bars registration of apartment owners association under the Societies Registration Act and advising such associations to be registered under the Cooperative Societies Act 1959. There are predominantly a lot of associations which are now formed under the Societies Registration Act. They are continuing to function. It is advisable that either such associations register themselves under the Cooperative Societies Act, because in the event of a dispute between a member and the association would not have any legal standing to go against a member who may default either in payment of CAM or anything else. So, which will render the association kind of toothless. So, it is advisable that such associations which are now presently functioning, having registered themselves under the Societies Registration Act, to either form a cooperative society, or if a deed of declaration has not been executed, to come together and execute a deed of declaration along with the bylaws, and then operate as an association under the Karnataka Apartment Ownership Act. Now, coming to the formation of the association itself, how does one form the association? As I discussed earlier, that the landowner or the promoter, which is the sole owner can be the landowner, or if the promoter is authorized by way of a general power of attorney, before executing the first sale deed or upon booking of 51% of the apartments, should register the DOD, which is the Form A, along with the bylaws. So, in effect, even before the first sale deed in respect of an apartment gets executed, the landowner can execute the deed of declaration along with the bylaws. This is done by some of the promoters. However, some of the promoters postpone the execution of the deed of declaration to a later date, which I would say is absolutely wrong, because unless the description of the apartment, the undivided share, the common areas, if there are any limited common areas, and everything else that is there in the apartment complex is not declared under a deed of declaration, the execution of a sale deed in the absence of deed of declaration all itself would be wrong, because the whole object of the Karnataka Apartment Ownership Act and execution of a deed of declaration is to make an apartment heritable and transferable. So, as promoters, those of you who are promoters must ensure that the deed of declaration is executed even before the first sale deed gets executed. In fact, some of the promoters execute the deed of declaration immediately after the plan sanction, or it can also be done after, once you have registered the project under RERA. The only hitch in this is that in the event there is any change either in the undivided interest or in the carpet area or super built up area, then subsequently you will have to go back and amend the deed of declaration. That is the only hitch in this. However, otherwise, if the intention is to construct the apartment complex strictly in accordance with the sanctioned plans, then a deed of declaration can be executed or should be executed before even the first sale deed is registered in favor of the authority. So, what happens if a deed of declaration is not executed by the landowner or by the sole owner of the land? Then, if that has not been done, it will become necessary for all the owners in favor of whom the apartments are sold to come together to execute the deed of declaration along with the bylaws. So, in some cases, as we have seen at the time of the execution of the sale deed, a special power of attorney is taken by the promoter in its name, specifically for the purpose of executing and registering the deed of declaration on their behalf. This can be done, or all the owners can come together and execute and register the deed of declaration along with the bylaws. The next is the case where the deed of declaration is not executed and the promoter has already handed over the maintenance without forming an association. So, in some cases, the association that would have been formed by the promoter would be the association under the Societies Registration Act. Most often, in 100% of these cases, the association that is constituted under the Societies Registration Act will not have in its objects the maintenance of the apartment complex. However, since the promoter forms these associations under the Societies Registration Act, these associations continue to function. In this case, the deed of declaration and bylaws can be executed by all owners coming together. This becomes difficult when the apartment complexes are large, where the number of apartments are large. However, all efforts should be made to execute the deed of declaration. And if it is, the other thing is that the deed of declaration can also be executed without annexing the bylaws, which means that the submission to the provisions of Apartment Ownership Act can happen by virtue of executing and registering the DOD and the Form B by the individual apartment owner. Then separately, the association can also be formed under the Cooperative Societies Act. The only hitch in forming the corporate, or the difficulty in the forming a association under the Cooperative Societies Act, is now it requires a minimum number of 20 promoters. There are certain deposits that are required to be made. The expenses that need to be incurred for formation of a association under the Cooperative Societies Act is a little more. And if the number of apartments is less than 20, let's say there is an apartment complex with only 16 apartments, then it again becomes impossible to form a cooperative society, in which case only an association under the KOA can be formed by executing the deed of declaration along with the bylaws. So the DOD has to be registered before the jurisdictional sub-registrar. Of course, of late, because certain proceedings were initiated as against some of the sub-registrars for having registered the deed of declaration along with the bylaws. This is what happened was that these deeds of declaration got executed along with the bylaws subsequent to the sale deeds having been executed. In such a case, the landowner cannot individually go ahead and execute the deed of declaration along with the bylaws. Some cases were there where such deeds of declaration and bylaws were executed, which got challenged. Some of the sub-registrars were also made parties to criminal proceedings. That is why the sub-registrars are now hesitating to register the bylaws. However, if it's just the deed of declaration without annexing the bylaws, I think the sub-registrars will, to my knowledge, the sub-registrars do not refuse to register. Now with the software being amended or the new software coming in for registration, I don't know the current position. However, just a DOD can be registered before the sub-registrar. So once the DOD is registered, as I spoke earlier, the true copy should be submitted to the competent authority, who is the registrar of cooperative societies, and you have to ensure that an acknowledgement is taken. It's just a submission and an acknowledgement being taken. There is also a practice of sending this through registered post, but however, I would recommend that you submit this and get an acknowledgement for the same. Once Form B, that is the deed of declaration, is executed, all apartment owners should execute Form B to submit their individual apartments to the provisions of Karnataka Apartment Ownership Act. Those of you who are promoters, one, make sure that you execute the deed of declaration along with the bylaws before execution of the sale deed. On the day when the sale deeds, the allottees are executing the sale deeds, ensure that the Form B is also signed. So these are the deed of declaration along with the bylaws and all the Form Bs is something that a promoter should hand over to the association once the association starts functioning. So what happens once the deed of declaration and the bylaws are registered? So the association can start functioning as per the bylaws. So what is the first thing that needs to be done? Once there are, let's say, the majority of the or sizable number of apartments in a project are sold, the promoter can facilitate in conducting elections for the post of the office bearers in the association as per the bylaws. Once the election is conducted and the results announced, these office bearers can then take over and start functioning as an association, specifically to carry out the functions of maintenance and management of the association. So the association which gets formed by virtue of the bylaws that gets executed along with the DOD is deemed to be an association of persons, and this association of persons can then apply for a PAN card, and then with the help of that PAN card open a bank account and also obtain a GST registration. This can be done. There is also, of course, the confusion that there is no registration certificate. It is not necessary to have the registration certificate because the registration of the deed of declaration along with the bylaws itself is sufficient to obtain a PAN card and then open a bank account and also obtain a GST registration. The only requirement would be to give an address proof. The association of the office of the association, if at all there is a separate space which is assigned as an office in the project for the association, or any of the apartment numbers can be given as the address. If any requirement is there to amend the DOD to add that address, that can also be done. Otherwise, any letter that is issued by the promoter to the association handing over the common areas, specifically this office premises, that can be used, which also I know has been done. The association, of course, then starts out to carry the maintenance of the common areas. The next is, of course, the RERA requirement of the common areas. The next is I'd like to, in brief, talk about the conflicts and resolution process in case of association. No specific resolution process has been defined under KOA, other than under section 23, to state that action can be brought by Board of Managers in respect of any cause relating to the common areas and facilities. The competent authority, who is the Registrar of Cooperative Societies in Karnataka, does not exercise jurisdiction over apartment owners associations formed under KOA for resolution of dispute. So you cannot approach a Registrar of Cooperative Societies, which could be an easier process, considering that it may be summary in nature and it could be adjudicated much faster. But however, the registrar of cooperative society has not been given any power under the act, neither do they exercise jurisdiction. So disputes between members or between the association and members would have to be resolved either by negotiation, or let's say that the association aims at recovering CAM dues, that is the common area maintenance charges dues from a member, then the only option would be to file a civil suit before the civil court for recovery of those amounts. And courts do recognize associations formed under KOA, unlike the associations that are formed under the Societies Registration Act. The associations which are formed under the Karnataka Apartment Ownership Act can sue and also be sued. So many cases that are filed even before the real estate regulatory authority, complaints can be filed by associations which are formed under KOA. Then, of course, the common disputes relate to maintenance charges, parking space, violations relating to building bylaws or restriction imposed under the DOD, and disputes with the promoter regarding corpus, handing over of maintenance, etc. This can also be the vice versa, as we earlier I was answering a question where the allottees don't come forward either to receive the corpus or the maintenance. Generally, the promoters agree to maintain for a period of 1 year from the date of the OC. And after the completion of that 1 year period, when the promoter starts to hand over, the allottees don't come forward. Either it's because the promoter does not make the handover process in a streamlined manner, does not hand over all the documents, or there are certain pending issues or snags that require to be rectified, because of which the allottees don't come forward to take over the maintenance. But let me tell you that merely taking over maintenance does not take away the right of the apartment owners or the association as a collective consisting of all the members who are the apartment owners to go against a promoter to seek for any remedies in case of any defects or defaults. It could be a defect in terms of the project work itself, or any other defaults in either, let's say, handing over of the corpus or rendering of the accounts relating to the advance maintenance charges. It doesn't take away the right of the association or the apartment owners to go against it, even after having taken over the maintenance. Like I said earlier, in case of disputes relating to corpus and handover of maintenance, you can also approach the real estate regulatory authority, and vice versa. The promoter can also go against an allottee if the allottee is not paying maintenance charges, has not paid maintenance charges, if there is an agreement for the promoter to continue with the maintenance work, or if the allottees are not coming forward to form the association. As I discussed earlier, apartments where promoter has not executed DOT, all the apartment owners can come together. The As I discussed earlier, apartments where promoter has not executed DOT, all the apartment owners can come together. As regards the withholding of essential services, the only provision or only statute which talks about it is COFA, where there is a restriction cast upon a manager from cutting off, withholding, curtailing, or reducing essential supply or service, which is water, electricity, lights in passages, lift, and sanitary service. So, what can be done to ensure that an apartment owner who is not paying the CAM dues and is overdue now is to restrain such a apartment owner who has not paid the maintenance charges, restrict him from using the clubhouse. Now, of course, that can be done because it is not an essential service. You can also restrict the delivery of food or groceries, whatever. So you can force that apartment owner to come down or go near the gate to receive. So these are the things which can be done to ensure that the apartment owner pays up the maintenance dues, because if many apartment owners default on payment of their common area maintenance dues, then the association there will be some stress on the maintenance activities, because then the other apartment owners would have to spend on behalf of those apartment owners who are not paying the maintenance. So of course, if the associations which are formed under the Societies Registration Act, the resolution process is under Section 15. But however, this cannot be taken in case of a association which is formed, which is carrying out the maintenance work. So inquiry is also contemplated by the registrar under Section 25, but this cannot be done in case of an association which is carrying out the activities of maintenance. So my advice to the associations would be that associations should set the processes right from the beginning itself so that mistakes are not made. So in terms of processes, how the MC works, how the important aspects of the maintenance are to be taken care of. Definitely, if processes are set, it will become easier to follow them to ensure that it is smooth. All associations require professionals to guide them properly. It could be chartered accountants, it could be engineers, it could be other consultants, it could also be legal professionals where there is a dispute that is there with the promoter. And of course, the handover and takeover process also should be in such a way that some amount of due diligence has to be done on the in terms of the technical due diligence. And if it's a promoter who is handing over, the promoter should ensure that all the documents in terms of the sanctions, the NOCs, the permissions that have been obtained, including all the so-called MEP drawings and all other working drawings, should be handed over to the association along with the title deeds, so that the association can take over the maintenance and start functioning. My advice to the associations would be that associations should set the processes right from the beginning itself so that mistakes are not made. So in terms of processes, how the MC works, how the important aspects of the maintenance are to be taken care of. Definitely, if processes are set, it will become easier to follow them to ensure that it is smooth. The all associations require professionals to guide them properly. It could be chartered accountants, it could be engineers, it could be other consultants, it could also be legal professionals where there is a dispute that is there with the promoter. And of course, the handover and takeover process also should be in such a way that some amount of due diligence has to be done on the in terms of the technical due diligence. And if it's a promoter who is handing over, the promoter should ensure that all the documents in terms of the sanctions, the NOCs, the permissions that have been obtained, including all the so-called MEP drawings and all other working drawings, should be handed over to the association along with the title deeds so that the association can take over the maintenance and start functioning. Um, very often, I have seen that there is a lot of hesitance on the part of the promoters to hand over, make the handover a smooth process. But if any of you are promoters, I think right at the stage of 50% completion, you should start thinking that this is a project which is ultimately be taken over by the allottees and you have to get out of the project. So keeping that in mind, I think preparations should start being made right at an earlier stage itself to ensure that the handover process is smooth. Because having sold the apartments to the allottees, if the handover and takeover process is not smooth, then that heartburn would be there, and then the issues would arise, and then it would make the job of an association difficult to take over and carry out the maintenance activities, which will also end in the goodwill of the promoter being lost. So after having constructed the apartment, sold the apartment, and handed over the apartments and the common areas, merely because you don't do the handover process properly, I don't think a promoter would want to take a bad name there. So the handover and takeover process should also be streamlined. And for associations who are taking over projects, you should ensure that proper due diligence is done and advice is taken by all professionals, be it an engineer, be it something in electrical, so or a legal professional to ensure that the title deeds are proper, or and a chartered accountant to see if the corpus that is handed over is proper, if the accounts relating to the advanced maintenance charges are rendered properly. So, of course, for associations, cost is a big factor in hiring good professionals. And associations choose based on cost. So most often than not, as a lawyer, I get a request to give associations how much I would charge for a particular professional service. The whole thing of wanting to hire a professional who comes at the least cost should not be the prerogative. I think the aim should be to get a better service in terms of hiring a professional who has knowledge and who comes well referred. So that should be the object. Please don't try to cut costs when it comes to hiring of professionals, because I have seen large promoters who have hired professionals merely because they come at a lesser cost. Nothing against such professionals, but I'll just take some of the questions. I'm just reading the questions on the chat box. Um, the first question is, how do we get the KOA 72 certificate? So of course, there is no certificate that gets issued. It is the deed of declaration which gets registered along with the bylaws. No certificate gets issued. A true copy of the deed of declaration along with the bylaws is required to be submitted to the Registrar of Cooperative Societies. By completing these formalities, you can, I will discuss that further as to how it can be, an association can start functioning under the bylaws of which get submitted along with the deed of declaration. Um, whether we need to pay the maintenance amount for a private terrace or open area, it depends on the bylaws. It depends on the declaration that is made and the bylaws. If this is to be charged, then if this is being charged, and if it is part of the bylaws, then of course it will have to be paid. Otherwise, it is by because it is a private terrace, it is a limited common area. No need to pay a maintenance amount for a private terrace area. Residents don't come forward to take over the maintenance of the promoter, and residents don't nominate for a formation of associations. What action can be taken to compel them to nominate? So under section 19 of the Real Estate Regulation and Development Act, it is now mandatory that all the allottees come forward to form the association. If that does not happen, and if it is a project which is registered under RERA, a complaint can be filed before the Real Estate Regulatory Authority against the allottees in the project, directing them to come forward and form the association. It is now possible to file a complaint, and this is the protection that a promoter gets in where the allottees are not coming forward to fulfill their obligations. So yes, a complaint can be filed in case of a project which is registered under the provisions of RERA. Private terrace with no access to other owners is considered for maintenance. In my opinion, no, it cannot be considered for maintenance, the common area maintenance. However, if such an area is required to be maintained along with the common areas, it will not remain as a private area. Then it means that the apartment owner who is allotted this private terrace should maintain the. But if the access to private terrace is required to be given for the purpose of maintaining the terrace or whatever is situated on the terrace, then such access would have to be given by the apartment owner. The next question is property is the property tax to be paid on UDS by associations besides the SBA to BBMP by apartment owner. The association does not pay tax on the UDS, but however, the association pays tax on the common areas like the clubhouse and other, if there are any additional amenities. So that has to be paid by the association. On the super built up area in respect of the apartment, the apartment owner has to pay the property tax. Next is can we get apartment registered under 1972? Because when they are denying, this is a question I will take a little later. How to register DOD, I'll also take that. Who has to initiate 1972 registration process? That also I will discuss further. Can a builder come back and build few towers after few years after because the FAR has been raised by the government? Once the builder has executed the deed of declaration, declared the common areas and handed over the maintenance, the builder cannot come back and seek to build anything additional on the apartment. Of course, this can also be enforced. Does DOD permit the association to levy a transfer fee on the buyer of an apartment from its owners? Like I said earlier, that it is a contractual relationship between the apartment owner and the association. If the association stipulates that a transfer fee has to be paid, then the member of the association would have to be paid. This is similar to if I can give a equivalent to this. If you're a member of a club, and if the club stipulates that there is an entry fee, there is an exit fee, there is a guest fee, so you end up paying these fees to the club without there being any question. It's similar in nature, but it cannot be unreasonable in case of an apartment. If something is very unreasonable, then of course an apartment owner can challenge it. But most often than not, this doesn't get challenged. And if something is applicable to you, and what one has to remember is that in an association which is formed for the purpose of taking care of the maintenance and management of the apartment complex, the members of the MC are none other than your co-owners of your neighbors and co-owners of the apartment. So I'm sure there is prudence in whatever um, fee that gets charged or levied for the different activities by considering taking into consideration all the factors. Only then it is decided. So yes, a transfer fee is which is now being charged by most of the apartment complexes would be I won't say whether the DOD permits, but however, if the as an association they can charge the transfer fee. Can DOD be registered and form be after majority owners have already registered? Can you please send me link of the seminar if already maintenance charges? Okay, I'll take the rest.
Government is right now trying to come up with a new kata. I mean, we were trying to do with
Yes.
the liar called Abhilash Nayak. Maybe you would know he is in the market. So, because of that, most of sub are saying we will not do because, and we are not the competent authority. Even though we have shown the High Court orders like we can register in 1972, they're not coming forward to do it, sir. If you are going to help us, we want to go ahead. I mean, we can talk this offline, but is this something you can help us to do it, sir? We can hire, I mean, you can support.
We'll take that up separately. Perhaps you can call me. Ah,
Yeah, hi sir. This is Suresh here. We are
yes,
staying in
yes.
Sakanagar.
Yeah.
Actually, if somebody build some in building in their private terrace, so that will come under common maintenance, whatever they build.
You are saying that there is a common, there's a private terrace which has been given
Yes,
on which somebody has gone ahead and constructed.
constructed. Yes, sir.
Whether that area would get included in the calculation for common area
Common area.
maintenance.
Yes, sir.
So that is something it will be peculiar to that particular association. Of course, if the MC either resolves to charge that as a to include that in the camp, that can be done, or perhaps you'll have to bring it up either in the AGM or in the SGM and pass the resolution to start collecting maintenance for such private terraces or private areas where construction has been done. Of course, the construction would itself be illegal. That's a different question. But for the purpose of maintenance, you may have to pass a resolution to start collecting maintenance on such areas.
Okay, sir. Okay. Thank you so much, sir.
Okay. Any other questions?
Yeah, I think I put up question, Mr. Sohail. We have met really great presentation. You took a lot of very valuable time to do this. Appreciate it. Thank you. And so this new KOA revisions, that's happening. So do we have an idea as to how long this will take?
As I know, it was to have been passed in the last session itself. However, that has not been done. Maybe in the winter session, if it gets placed, it may come through.
Okay. Any insights to what are the changes or?
No, absolutely. I don't have any idea. I hope they do a good job. Tamil Nadu has done a fairly good job with the new law itself. Perhaps if they can adopt and tweak that to our requirement, then it will be good. But otherwise, I don't have any insights on that.
Oh, great, Mr. Sohail. Yeah. Thank you. Yeah.
So, okay, I think we've taken more time than I thought it will go on for. Thank you so much for joining. And of course, this will be available on YouTube as a recording also. I thank Rera Consultants LLP, Vishwas and Pradeep for giving me this opportunity. Thank you all.
Thank you, sir.
Thank you. Thank you.
Now, our Pradeep sir will give a vote of thanks to this webinar, sir.
Thank you, Shwas. Thank you, Suhil sir, for sharing such a wealth of knowledge with us today on formation of Apartment Owners Association. Your detailed insights into the legal framework and practical challenges and the recent developments in the field have been invaluable. We truly appreciate the time and expertise you have dedicated to help us understand this important topic. I would now like to extend my sincere gratitude to everyone who made this session possible. To our speaker Suhail sir for enlightening us, to our Organizing team, Vishwas, Digital Marketing Executive from RERA Consultants LLP, for his efforts in coordinating this event smoothly. Especially to the participants, special thank you for your engagement, thoughtful questions, and interest in this topic. Your participation has enriched the session and demonstrated a shared commitment to create well-managed and legally compliant residential community. As we conclude, I hope today's discussion leaves you with a clearer understanding of the process and responsibilities involved in the forming an apartment owners association. We look forward to seeing you at the future sessions and continuing to support you with the insights and expertise on RERA related topics. Thank you again. Thank you all. Have a great evening.
Thank you. Thank you. Thank you, Pradeep.